All right, is that working? On the right slide?
Looks good.
All right, it is 10 a.m. Good morning, everyone, and welcome to this presentation. I think this has been one of the most eagerly awaited presentations. Um, uh, it seems like SB 43 has been coming for the last 4 years, as we've been anticipating and waiting and following along as this law has been modified and changed over the years. But it sounds like we are finally on the precipice of it going live here in January 2025. And so we are excited to have this time for us to come together and learn. A few housekeeping things. Yes, please make sure that you keep yourself on mute. We will have questions and answers throughout the presentation, and we will have some time after the presentation for additional questions and answers. If you are wanting to receive credit for CME, for pharmacy and continuing education, for CEUs, for our LCSW or LMFTs, please be sure to text your attendance, and that is important for um, capturing your participation. You will also receive an email afterwards with a survey for course feedback, and that is required also for credit. So we're excited to be offering this continuing education because I think this is also not only important just for practical reasons because we want to understand the change in the law, but also this is very much applicable to many of our law and ethics credits. So this morning we have Mike Phillips and Marielle Horner joining us from Jewish Family Services, a part of the patient advocacy program. And we're so grateful for them being willing. And I think they're on a community roadshow here, going to all of the places and doing these presentations. And they've been tremendous advocates in our community and supporting, I know, our hospitals with many issues. And so we're very grateful for their participation and joining us today. So I'm going to, Dr. Nicholas from Sharp Mesa Vista Hospital, our Chief Medical Officer for Behavioral Health at Sharp HealthCare, is here as well and will be participating and facilitating discussion. And we are also, again, here to support any questions and answers throughout the session and also specifically at the end. But with that, I will turn this over to you, Mike and Marielle. Thank you again for joining us. Good morning.
Good morning. Thanks, everybody, for having us. This is a topic that is, some of you may have a full understanding. Some of you may be hearing about it for the first time. So we want to encourage questions along the way. We'll have time for feedback and questions at the end as well. And we will remain an ongoing resource to all of you as we get closer and closer to January 1st. So the short version of this is that the definition of grave disability, as it's been for about 57 years now, is about to expand. So that has systems implications, that has civil rights implications, that has financial implications. And so we're going to get into the details. But I'm Mike Phillips. I'm the Senior Director of Patient Advocacy and Housing Services for Jewish Family Service. Marielle Horner from our team is here. She is the patient advocate dedicated to this training that we're doing. We've been asked by the county to have these conversations, have these trainings, and work with the community to talk about what's coming and what do we know so far and what are the things that still remain. I'm sure you're going to have a lot of questions. And at the end of this training, you're still going to have a lot of questions because there's still a lot of things that need to happen before we can fully implement. So if we could go to the next slide. I think I mentioned already that we've been tasked by Behavioral Health Services to help with the training. So here we are. And the law was passed in about about a year ago now. But the counties, the individual 58 counties, were given the opportunity to decide when they were going to implement, and we'll reference that in slides coming up. But um, the only two counties of the 58 counties of California that decided they wanted to implement immediately were San Francisco and San Luis Obispo, and they did. But it sounds like it has not been easy. There's a lot of struggles. The remaining 56 counties have delayed implementation somewhere between the beginning of this last year that we're in now, and the mandatory final date to implement is January 1st of 2026. And so we chose, San Diego County Board of Supervisors chose right down the middle. We're going to implement at the halfway point, which will be January 1st of this coming year, 2025. So I think that covers this slide. So we can go to the next one. And we want to talk a little bit about, just a reminder. Mario's going to talk a little bit of a reminder. I think we get so caught up in the bubble of what is SB 43 that we forget, well, what is the whole what did the whole LPS Act about? What was the LPS Act trying to do? Because SB 43 is not meant to radically change the intention of the LPS Act. It's meant to change the definition of grave disability. So I think to ground this conversation, Mariel's going to walk us through a reminder of what the legislative intent of the LPS Act is and has been since 1967. You're up, Mariel. I don't know if Mariel's still here. Okay. I'm going to keep going because I don't know what happened to Mariel. All right. So the purpose of the LPS Act is to, and you remember at this time, this is a time, let's focus on what that time period was. This is at a time when the state hospitals were being shut down. They were expensive. They were old. They were in many cases inhumane, politically problematic with some of the stories that were coming about what was happening in those facilities. So when we read it in that context, I think the LPS Act really makes sense. So I'm just going to go through these. The idea was to end the inappropriate, indefinite, involuntary commitment. The understanding was that some people were just sort of disappeared to these state hospitals and then gone for the rest of their lives. To provide prompt evaluation and treatment. So if someone needs treatment, whether it's psychiatric or medical, the treatment would be provided promptly. And to guarantee and protect public safety. This was a way to try to balance civil rights versus people maybe wanting to harm themselves or wanting to harm others. So the LPS Act is really a balance to say how much can we make sure that people have a right to be themselves, but if they are doing something dangerous, we've got to step in. And then provide individualized treatment. Safeguard individual rights through judicial review. Many of you know we do due process hearings, due process certification review hearings when people are placed on 14-day holds, 30-day holds in the LPS facilities. We also have the writ hearings. We don't do those. The public defenders do those. But if you're being detained, you also have the right to ask for a writ and go downtown. And we're going to talk about that because there's pieces of that SB 43 changes as well. And then 5, to provide individualized treatment, supervision, and placement to make sure that we're doing case-by-case individualized assessments for individuals. Let's go to the next slide. And if Mariel, if you're here, feel free to jump in at any point. If not, we all know I can talk forever. Okay, and to encourage the full use of existing agencies. So this again, and this is really important in the context of SB 43, is no one partner is going to be able to implement SB 43 alone. We already know that the system is overloaded and overtaxed, and we are going to have to work together with a lot of different partners to make the SB 43 implementation work. And to protect people with mental health disorders, developmental disabilities from criminal acts, to provide consistent standards for protection of personal rights, and to provide services in the least restrictive setting. So we're talking about an expansion of an infringement, if you will, on civil rights. The net of who can be detained pursuant to 5150 is about to get a lot bigger. And so that has civil rights implications, as I mentioned before. It's also going to have systems implications. Is this going to be a massive tidal wave of new people coming to your facilities, coming to your emergency rooms and your behavioral health units? Or is this going to be the same people you've been seeing before, but just using a different definition or somewhere in between? Likely it'll be somewhere in between. And the data that we've seen out of San Francisco and San Luis Obispo, which is not totally indicative of what we should expect to see in San Diego County, isn't super informative yet as to exactly what we should expect to see the impact to be. I think we'll start seeing that on January 1st. A lot of the counties are implementing on January 1st. And so we're going to have to see what that impact is when it arrives. Next slide, please. So I want to remind everybody about the concept of voluntary, and there's a lot of reasons why I think this is helpful, is especially in the context of AB 2275, which I'll remind everyone is the law that went into place a year ago, a little more than a year ago, a year and a half ago, that was an attempt to bring due process to individuals who were detained pursuant to 5150 in a non-LPS setting. So you know that out in your, not at, if you're at Sharp Grossmont, you're at Sharp Mesa Vista, that's one thing, but at the non-LPS facilities, if somebody comes in pursuant to 5150 and that 5150 expires and they're still there, that person's supposed to get a due process hearing similar to what they would have had if they were in the psychiatric behavioral health bed on a 5250. That is an imposition on all of you. That's not easy for you to have the time and the people to do those due process hearings. But one of the things that we like to promote is if that patient at any point after they've been brought into pursuant to 5150 is willing to be a voluntary patient, then that breaks that chain and that person would not necessarily need to have a due process hearing. So, and always we're pushing for voluntary status because the law always pushes for least restrictive. And there's an Olmstead case, a Supreme Court case, some of you may be familiar with it, really pushes for the least restrictive settings in all environments when it comes to disabilities and treatment settings. So please continue to prioritize asking if someone wants to be voluntary. And if anyone needs a subsequent class or a follow-up or a training on how to calculate the days when someone's been placed on a hold and then they go voluntary and then they want to leave and then they get placed back on a hold, that can be super tricky. But you have the ability to, and I see Mariel's back, you have the ability to continue to let people be voluntary and switch them back to involuntary for a pretty long period of time. We've got up to 47 days now that someone can be detained pursuant to a 5150, followed by a 5250, followed by a 5270. And then this last year, there was a new hold that went into place where there's another 30 days that can be added after the first 30 days. That's one that you've got to go downtown to get. And if anyone has questions about that, we're happy to speak to that as well. It's a fairly new one. But under grave disability, and now under the expanded definition of grave disability starting January 1st, you could presumably have someone detained for up to 77 days. That's a long time. You may not want to have somebody for that long, but if you need it, you'll have it. So definitely willing and able to have conversations around all of these tools to the extent that you may need some additional education or more familiarity with them. Anybody that's willing and able to receive services. So just a reminder, the definition of voluntary is a person who is willing and able to receive treatment should be allowed to be voluntary. We know sometimes that ambulance and EMT will try to force you all to put people on to put people that are otherwise voluntary on a 5150 to get them transported to the right place. They should not be doing that. We have laws that we can show that were recently passed that indicate that should not be happening. We know sometimes you're stuck in a position where you just need to get that person moved, but there's a bunch of consequences that flow from being placed on a 5150, and those are consequences that should not be hitting those individuals if they were not truly involuntary. So if you want to have conversations on that, we can talk about that too. And then let's see. Yeah, and then as soon as somebody, even if they came in pursuant to 5150, as soon as they indicate a willingness to receive treatment voluntarily, they should be allowed to do so. And also, we would ask, try not to let the acuity of that person or continuing dangerous behaviors be a reason to not let someone be voluntary if that person is saying, I want to be here and I want help and I'll go along with the treatment. We sometimes hear when we have these conversations with providers, they'll say, well, this guy was just trying to kill himself this morning. Yes, but if he's saying that he wants to be there, he wants help, and he wants to go along with the treatment, that's still voluntary. Now, if the person's acuity is so high that they can't uh, with a competency or capacity lens make that decision, then that's a different story. They should have an understanding of what it is they're agreeing to. But we like to try to say, don't let the fact that the person is still doing some sort of self-harm or still experiencing symptoms be a reason to not let them be voluntary. I've seen it, and I'm sure you've seen it as well. When you've got a patient working with you and you're working together, there's a dynamic that changes as opposed to, as one patient told me, in fact, this was at Sharp Grossmont years ago. This patient wanted to be voluntary, and the doctor said no. And the patient said, I want to be here. Why does it have to be like this? Why does it have to be like this? So I would imagine as providers, if you don't have to deal with this, then that helps. And none of this is as simple as I'm describing it right now. I'm not naive to that, but just a reminder to please always be considering voluntary status. Let's go to the next slide. If Mariel, if you're here, I'll finally stop talking.
I'm here. Sorry
All
about
right.
that. I
All
was
right.
having some connection issues.
All right.
Of
Go for
course.
it.
Okay. So to touch on what Mike said about voluntary status, the goal, especially since we have some clinicians in here, is collaborative safety planning to reduce involuntary hospitalization. That's always very important, but we do understand that sometimes that's not possible, or there's still, a doubt that an individual can keep themselves or others safe. So the criteria to detain, just a refresher, is danger to self, danger to others, and grave disability. And as our focus today is on grave disability, we'll break that definition down pretty consistently and clearly to provide clarity from some of the questions that we've already been receiving from other providers and agencies. So we will get into that. Next slide,
And
please.
just a reminder, real quick, before we change slides, or if we could go back for a second, there's a lot of urban legends around all three of these criteria that have crept up over the last 57 years. There is no definition of danger to self. There is no definition of danger to others. That's it. That's the whole definition. So that gives you a lot of latitude to decide what you think that means. Those determinations would be subject, of course, to whenever there's a hearing or a due process hearing, and there'll be questions about whether you applied that in a reasonable way. But I just want to make it clear there's no definition of danger to self and no definition of danger to others. We're going to talk about the current definition of grave disability and what it's going to change into. And if we could go to the next slide, I want to remind everybody what the threshold is for all these criteria and putting somebody on a hold. So in the law, as you're probably aware, there's multiple different burdens of proof. And a burden of proof essentially means how much evidence you need to do a certain thing or how much needs to be proved in a certain case, a civil case or a criminal case. I'm going to do a really quick burden of proof class. I'm going to say down here at the bottom of the screen is 0% proof or evidence needed. And up here at the top is 100% proof. So we'll go through. The lowest is reasonable suspicion. Very low after that is probable cause, and that's where we're going to be during this whole conversation. Very low burden of proof. And then at about the halfway point is preponderance of the evidence. About 75% of the way is clear and convincing evidence. And then just about at the top is beyond a reasonable doubt. So these are your criminal trials up here, and then your civil trials are usually down here. But probable cause is a very low burden. And it was defined in the LPS world in a case called People v. Triplet. So I'll just read it. You can all read it, of course, too. I promise not to be one of those trainings where everybody just reads the whole PowerPoint. But the wording on this one, I think, is important just to know what the definition of that burden is. So it's you have to constitute probable cause to detain the person pursuant to 5150. State of facts must be known to the peace officer or other authorized persons. That would be some of you. That would lead a person of ordinary care and prudence to believe or to entertain a strong suspicion that the person detained is mentally disordered and is a danger to himself or herself or is gravely disabled. In justifying the particular intrusion, the officer must be able to point to specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant his or her belief or suspicion. Really what that means is it's basically a reasonableness standard. And the burden is so low, I usually describe this in this way. If you're out with friends at a happy hour that don't do what you do for a living, and you were describing what was going on with this individual, as soon as most of the room says, yeah, okay, yeah, I get it, that makes sense, then you've hit that standard. It's very low. And the reason that that society is allowing this very low burden, because this is a real infringement on someone's civil rights to the extent that they can be taken in handcuffs in a patrol car to a hospital and provided with treatment against their will, sent a bill for the treatment. It can be very traumatic, even when you're all trying to do your best. The trade-off is they're going to have a low burden to detain someone just in case there really is danger. But then you all, when they get to the hospital, are going to assess, decide whether that was appropriate, maybe switch to voluntary, maybe discharge with resources of the community. And then the due process mechanisms are going to come in to check and see, was this really warranted? And so that's the trade-off is if there's an emergency out in the community, they don't want the burden to be way up here because then no one's going to be brought to the treatment facility. So you bring that burden down, but you have these different checks and balances on the back end. It's not clear whether this definition from 1983 will survive and be the same definition for grave disability once it changes in the state of California for all the different counties. So this definition may change. I want to point out specific wording around specific and articulable facts. Those of you that are filling out 5150s and those of you that are filling out the 14 days or the 30 days, your best bet on those is to really write these specific and articulable facts. A lot of times clinicians will write conclusions. They'll say the person's combative, isolative, irritable, things like that. And that is a conclusion based on the underlying facts that you use to make that conclusion. Sometimes when you just write the conclusions in those forms, then those people are going to get released at their due process hearings because the hearing officers don't want to hear the conclusion. They want to hear what you used to form your own conclusion. And if you put those underlying facts, they will most likely agree with you. And then that patient will likely be detained and you'll be able to continue to do whatever treatment you need to do. So I wanted to use this opportunity law enforcement's really good at this. Law enforcement just puts specific facts. Person was walking around naked downtown on a bridge, throwing rocks at a car, hasn't eaten in 3 days, thinks they're Jesus. So specific and articulable facts are super important on your documentation. Okay, and we will move on. And again, we can answer questions along the way or at the end.
Before we do move on, I see Kirsten has her hand up.
Great.
Kirsten.
I really want to, because what you're hitting on is one of the kind of critical barriers that we at Short Mesa Vista are currently contending with when we're looking at the expansion of grave disability. For particularly our Medi-Cal patients, with Optum being the payer, they will not pay for voluntary chemical dependency treatment in our settings. It's not a part of the contracted benefit. So one of the things that we've really struggled with is how are we, with the expectation that so if we have a patient that presents that voluntarily is seeking treatment for chemical dependency, their payer, their insurance will not pay for them for hospitalization if they are voluntary. They will only pay if they are held on a grave disability hold. And so really looking to because at that point, it does feel very much like a catch-22 for the person that's really actively seeking treatment. And voluntary treatment for chemical dependency is dependent on the person's ability to pay. So how are you all interpreting this as far as for our acute care behavioral health? What I've heard from the health plans is that their expectation is that these patients will be admitted to the medical hospital for their detox if they're voluntary. But I don't think that the acute care medical hospitals are prepared for admitting patients for detox. What is your stance?
and I appreciate the question. We haven't really gotten into sort of the mechanics of what all these things are yet, so I don't want to punt the question too far down the road. But you're exactly right. Is where, if we've expanded this definition, where are these individuals going to go? Do those facilities even exist? And then who's going to pay for all of it? And I've been doing this for a long time. I've been doing this probably over 20 years now. And even before we started talking about SB 43, the concept of voluntary has always been a tough one because patients have a right to be voluntary, the right to receive voluntary treatment. It's more humane, it's more dignified. But almost every vector in the real world seems to cut against that. There are people in ambulances saying, put the person on a hold. I don't think I can transport them without it, or I just feel more comfortable with that. There are receiving facilities, as I'm sure you're aware, saying, put that person on a hold. We'd rather receive them on a hold. There are doctors that are saying, I don't want somebody waking me up in the middle of the night and saying this person wants to leave, put them on a hold. There are insurance companies who believe and suggest exactly what you've just said, which in many cases, I won't say to your point, is not legal, but in many cases there is parity where there's not supposed to be a difference between reimbursement under voluntary or involuntary treatment, but yet we know that does happen. So there are almost every vector in the real world pushes against a voluntary patient being voluntary. And not only does that make the treatment alliance, I think, more difficult, but it also kicks in a lot of, and we'll mention towards the end of this, a lot of weapons prohibitions and that kick in for people that have been placed on an involuntary status. So if I'm in law enforcement or the military or security, or I like to hunt, and I end up needing some treatment and I go in for some treatment voluntarily and I get put on one of these holds, there's a good chance I'm going to end up on a weapons prohibition list and be banned for 5 years or life in a lot of cases from ever owning a weapon. These are things that could be career enders, and maybe they should be in some cases, but I don't have an answer to that, although I am going to follow up with the BHS afterwards and see what their official position is. And is that specific, just to clarify, that specific to chemical dependency? You're saying that Optum will not reimburse if it's voluntary?
In the acute care behavioral health.
In the acute care behavioral health. Got it. Okay. I will follow up.
Thank you.
Claudia, I see your hand up.
Hi, yes. I was just going to comment on this, and if it needs to wait till later, totally fine. But kind of my background, I came from Washington State, and I implemented the 72-hour holds, is what we call them, 5150s out there, as well as the 14s, 90s, 120s, and did a lot of the court testimony. I was present when Washington State underwent this same exact transition about 4 or 5 years ago, where we ran into the issue of expanding the definition of grave disability to now be able to incorporate those with pervasive and persistent substance use disorders and complex acute psych. And one of the things that we did bring to the state was this issue of things like Optum and the BHO's willingness to pay, as well as not having the appropriate facilities to just treat acute substance use alone. And
Right.
so in the involuntary role, what I would end up doing is I would have to look at the patient's presentation, determine if there were grounds and flexibility to have the option to detain them for substance use, but ultimately detain them for a mental health issue in relation to their symptomology, in hopes that from a dual diagnosis perspective, the inpatient psychiatric unit would cover the acute substance use concerns along with the psychiatric. And then when that patient is hopefully able to become voluntary, step them down into some sort of outpatient. Now, of course, some of those patients still have to pay and some of those organizations still won't pay, but the acute risk has been addressed and they can be returned to the community.
Yeah, and that's definitely helpful. It's unfortunate as these things get rolled out, and I'm not a fan of SB 43 because from a civil rights perspective, we are
right
trying to address or pretending or suggesting that we're going to solve some aspect of the unhoused problem by detaining a bunch of people and bringing them to you all. And we know that those issues go much deeper than that. So, and from a civil rights perspective, I think we're seeing the pendulum swing the other way, and that's maybe not a bad thing, but from my perspective, I'm not a big fan of that. But what I also am not a fan of is what you just said. What you said makes perfect sense, but it sounds like we're already starting to have to think about how do we distort the intention of whatever this is supposed to be in a way that makes it work. We're having to bend to fit into categories that maybe are not the categories we wish we could use, just to sort of either implement the law or survive, whether it's financially or be able to provide the treatment that you believe is necessary. So that's something I think we all just want to keep in mind, and it's going to happen because that's what we do as humans, and we're trying to provide good care and work with limited resources. But that's an unfortunate consequence if that's how it has to be. Let me follow up with BHS on an answer for Optum, and then and all this stuff. We can follow up on all these things. So we'll keep going because we got a few more slides. But I really like the participation.
Okay. Yeah, I would like to add as well, my background is very clinical, and Medi-Cal and Optum present us consistently with a huge challenge, especially in getting individuals safe medical detoxification and then the follow-up. Where's the treatment? So we want to acknowledge that and validate those concerns. So enter SB 43. So SB 43 is a huge expansion of the definition of grave disability. As we know, we're now including severe substance use disorder as an allowable category for someone to be compelled into involuntary treatment or placed under conservatorship. There's also two new aspects under our definition to meet the criteria that are being introduced. It's personal safety and necessary medical care. We will kind of break those down to the best of our ability because the definitions as they stand right now, especially in the legislation, are very vague. But this is part of a basic personal needs and allows for wider discretion of the court. San Diego County will implement SB 43 by January 1st, 2025, per the Board of Supervisors resolution. Some counties in California are already implementing this, but the general deadline statewide was January 1st, 2026. So San Diego County kind of falls in the middle, and like Mike said, we're following up and trying to get more information as to, I mean, how many individuals can we anticipate to receive care? How will our facilities be impacted? And kind of where do we take them and where do we go from there? Next slide, please. So our current previous definition of grave disability is exactly a condition in which a person, as a result of a mental health disorder, is unable to provide for his or her basic personal needs for food, clothing, or shelter. The mental health disorder, food, clothing, and shelter are not specifically defined. Also, from a civil rights perspective, someone simply being unhoused does not mean that they are gravely disabled. Finding placement and finding a safe place to go is always an issue that should be considered, but them just being unhoused is not gravely disabled. Next slide, please.
And we'll just throw this in. This one can be kind of confusing. And actually, Mary, let's move this. I want to move this slide further down in the future, but I think it comes a little too soon in the presentation. But the concept of minors, does this apply to minors? Now, many of you know, and many of you may not know, that there's a different definition of grave disability when a minor is detained. And it basically speaks to these elements of life that are essential to safety. This is a very sort of poetic definition. I'm guessing some law clerk wrote this, but the idea being that a minor does not have to provide for food, clothing, and shelter, but if provided for them, they need to be able to utilize it. And if they're not utilizing it due to a mental health condition, then they can be detained. And that definition exists. It's in the law under 5585.25. The question then becomes, well, does that change too? Will that change with SB 43? And very awkwardly, based on some recent case law, which I won't bore you with unless you're interested, you can reach out to me later. Based on some recent case law applying to conservatorships of minors, this definition of grave disability will remain after SB 43 for the 72 hours under which that minor is detained. But if that minor is detained for any longer amount of time than that on other holds or ultimately placed on conservatorship, the new definition of grave disability will apply to that minor. So that is very confusing. And that is codified in 5585.20 after a recent conservatorship case. So this old definition, basically food, clothing, and shelter, but you don't have to provide it yourself, but you got to utilize it if somebody provides it for you. That's grave disability for minor. If that minor gets put on a 14-day hold or any subsequent hold, it'll now flow into the new definition of grave disability. Super confusing, but that's what it is. So let's cover the new definition. So as Mario gave us the old one is still here in the non-bold and non-underlined, but these are some pretty dramatic new additions to the law. For 57 years, the LPS Act has been a mental health law act only, somewhat frustratingly so, as some of you have already pointed out some things where it sort of assumes that everyone's got no co-occurring anything and no medical issues at play. We know now that everybody, well, not everybody, but a lot of people have multiple co-occurring everything, and it's really hard to treat or detain using these tools if the right tool doesn't fit. So again, out of Sacramento, there's no mystery here. This was designed really not for the 5150s and the initial holds. This was designed to make it easier to put people on conservatorship. We're seeing a transition now. If you look at Care Court, which creates a court mechanism and a process, if you look at SB 43, which softens or lowers the threshold for grave disability, and then the question, well, where will all these people go? Proposition 1, which was passed in March by a very small number of votes. I think out of 7 million voters, it only passed by 20,000 votes. But that will, among other things, create $4.38 billion in general obligation bonds, which will be then spent on building new facilities and new treatment options. Some would say on the civil rights side that this feels like a return to mass hospitalization, institutionalization. So I think that's something that we want to kind of keep an eye on and be honest with ourselves. Are we going to solve the housing problem by taking everybody to you all and then ultimately putting them on conservatorship and then putting somewhere else? I don't know. Do we have the right number of treatment options now? No, we don't. So this could go either way. But it's very dramatic in that for the first time, severe substance use has been added. There's no reference to severe substance use anywhere else in the entire LPS Act. And think of those two as the nexus. So you've got to have the nexus of either mental health or severe substance use or both to then lead to, that's still not enough. Those two things are not enough to detain someone. It's got to lead to these other behaviors. And as we said before, food, clothing, and shelter, as Mariel pointed out, not defined. But now we're going to add personal safety, which is super vague, and necessary medical care, which is pretty narrowly defined. But the idea here, you can get a sense of what's going on here. We're talking about people that are out in the community and are unsafe, and we need to put them some other place. So those are the new words that are added. Now let's go into breaking down what those definitions are. I see a hand up too. If we want to, I don't know if we want to take that now or however you all want to do it.
Go ahead, Denise.
Hi there, it's Denise. I was wondering if there's going to be any changes to the hearsay exception
There
when we
is.
have family members coming in and reporting something that's inconsistent to what the patient is saying.
So not to that part, and there's a slide that comes up later on that talks about this. SB 43 does make other changes that are not the ones we typically think of with the definition changing. But one of the things it does, and we'll talk about it later, but just to answer your question now, what it will do is in some cases make it easier for if someone is going to downtown to the courthouse for a conservatorship appointment or reappointment, then in some cases it will not have to be the physician that goes down to testify, which we know can be a problem when you've got a physician that needs to be seeing patients and ends up sitting downtown all day in a courtroom. Under certain cases, that physician would not have to be the person that shows up, and another provider could show up and testify. But to your point, it doesn't make any changes to, and I think what you might be referring to is under 5150 and 5150.05, there is language that says third parties can provide information to you all about what they say is going on. If they are making things up or lying to get someone detained, there is civil liability for having done that. Is that what you're referring to, or is there a different piece?
No, that's exactly what I'm referring to.
How is that?
When there's conflicting.
How is that problematic? How does that play out for you all? I mean, what needs to be fixed in your mind?
So say that family members bring somebody in here, which we have all the time, and their idea is that this person needs to detox, so this person needs to go to treatment. And so family is giving reports like, oh, they stopped going to work, they're not getting up from bed, they're not interacting with the family. Person comes in here, they're disheveled. And of course, like you have been talking about civil rights, I mean, the right for self-determination, right? But the family is thinking that they're deteriorating, that they're having a medical emergency along with a potential mental health emergency. So like, what do we do with these folks when they come in after January 1st?
Yeah, I think that it's always been, and under 5150 and 5150.05, the language, which is mostly directed to law enforcement, but applies to you all as well, is that they can provide that feedback and then you shall consider it. The shall meaning you must, but consider meaning you can say, well, I hear you, but we're not seeing it. So you all have the ability from a clinical and professional perspective to factor that into your overall determination, but you should not be beholden to it. You should not be forced to let that dictate your treatment. That should be the clinical team that's considering that. You must consider it, but you are not held hostage by it, or you should not be held hostage by it. So that's just going to be part of the ongoing clinical team conversation.
Thank you.
See another hand up?
Yes, Kirsten.
Yeah, on the previous slide, I'm sorry, and there was a piece there that I don't think that I captured. Can you go to the previous slide where you're talking about the expansion? And it looks like, okay, so am I interpreting that correctly, that there is an expansion added to the medical care piece when you're saying emphasis added there?
Yeah. Well, everything in bold, everything that's in bold and underlined, we added the underlined and the bold and that's what emphasis added means. We altered not the words, but we altered the italics and the bolding so you can see what's new. But yes, necessary medical care is new, personal safety is new, severe substance use disorder is new. And there's definitions for each of those that we're going to go into.
Oh, okay. Thank you.
Okay. All right, let's keep going.
I think we need to go back one, please, Josh. Perfect, thank you. Okay, so this is kind of where we enter our clinical territory, the meat and potatoes of the new definition. So I'll just read off exactly what the definition of a severe substance use disorder is. It means a diagnosed substance-related disorder that meets the diagnostic criterion of severe as defined in the most current version of the DSM-5 TR. So if you are active clinician, you will know that there is a scale on substance use disorder: mild, moderate, and severe. In this instance, for the expansion of grave disability, individuals need to meet the threshold for severe substance use disorder, which is 6 or more of the 11 symptoms listed in that criteria in the DSM-5 TR.
And this is going to be tough because presumably law enforcement will be the front door, as they always have been, to a lot of the people that come to you. Law enforcement cannot be expected and will not be expected to be diagnosing. I mean, I'm going back and forth with some of my colleagues at PERT. Now they're focusing on the language that says means a diagnosed substance-related disorder. That presumably means that there would have to already be a diagnosis in place. And how would law enforcement know that? Because of course they wouldn't. Also, law enforcement is not going to be, nor would we want them to be, going through the 6 out of the 11 DSM criteria. So we should imagine that police will not be using that criteria, nor have they been experts or clinical professionals in the determination of mental health, which they've been detaining people on since for the last 57 years. So we should assume law enforcement will have sort of a layperson's perspective on what they think is going on, and then bring those individuals to you. You then will need to decide what you're going to do with these definitions. And is that person detainable? Should they be voluntary? Should they be discharged based on that? And there's a lot of loaded stuff in that and what I just said. So that's going to be a lot of stuff you guys are all going to need to talk about to figure out what this looks like for you. Next slide, please. Personal safety, that my civil rights heart cries on this one because it is so ridiculously vague. Personal safety means the ability of one to survive safely in the community without involuntary detention or treatment. Basically, if somebody thinks you're unsafe, you're getting locked up. And I don't think that it means to say this, but that "or" is a critical word because it basically says if you can't survive safely without detention or treatment, meaning we could lock somebody up without treatment if they can't be safe otherwise. I don't think that's what it means, and I sure hope that's not how it's going to be implemented. But as written, you could detain me if I'm unsafe and need not even provide treatment. And that this is where the net gets really broad. I mean, it keeps getting broader, understandably so, with the way the pendulum swings. And I'll say just for a second, if I can, back in the 60s, I wasn't here for that, but the idea was like terrible conditions, self-determination, civil rights. And what we see is some people feeling like maybe there's too many civil rights or there's not enough people availing themselves of care. But I would argue that we never really truly, as a community and society, built that system of resources that allowed people to have the access they needed when they needed it, affordability, variety of levels of different kinds of treatment. And so we've seen people that maybe wouldn't have availed themselves of treatment no matter what. And we've seen people that said, hey, I'd like to, but I can't get to it. And so what we're doing now is we're saying, well, we gave you a chance, which we really didn't. And now we're going to have to do this the hard way, and we're going to have to start bringing you in against your will. I wish we would have been able to truly give that chance. And then I think I would feel a little more comfortable about what we're starting to do now. But I think we're blaming the victim in many cases for not availing themselves of services that didn't exist. And now, in some cases, we're going to be forcing them into services which still do not exist. So there's a little bit of a logic model flow through problem in my brain. But with that, let's just go to the next slide.
Okay. Now for necessary medical care. In shorter terms, this means that if there's an existing physical medical condition which is left untreated and the lack of treatment is likely to result in serious bodily injury. So this can be determined by a licensed healthcare practitioner within a scope of practice. So that is a lot of words and still very vague within the many words. So we partnered with PERT to kind of come up with some examples of that. So one example could be a lack of wound care leading to infection, likely to lead to loss of limb or life. That can be observed a lot tying into the substance use piece, intravenous drug use, fear of going to the hospital to seek this medical care due to stigma, or now we're introducing that aspect of involuntary treatment. Also untreated comorbidities such as diabetes, renal failure, my work in the community, I've observed individuals living with diabetes with blood sugars at 300, 400, lack of compliance with insulin, and that's led to serious medical emergencies. So the hope with that is to address those things, but it's such a wide net and something that we're continuing to try to pinpoint on kind of what a definition would look like. So hopefully just those examples helped to the extent that they can while we still kind of navigate these new aspects with the definition.
And just a reminder, all those examples that Meryl just provided, none of those are part of the law. So these are things that we
Right.
as communities are starting to develop to try to make this more practical. But the what we have as the legal definition is what we're showing you. And everything else that we say is something that we or other members of the community are making up to try to say, well, what does that look like in the real world? Looks like we got a hand up.
Yes, Lynn.
Clarification, this is really confusing. The necessary medical care, refusing the necessary medical care due to a mental health issue, or is this not even, there's not a requirement to have a mental health issue?
No, it's a great question. So if it is determined by clinical professionals that I, for example, have a medical condition that is very serious, and due to a mental health or substance use, severe substance use disorder, or both, I am, from your opinion, not going through with the plan, then you can detain me for that. The classic example I like to give is, and I've seen it, you've all seen it, I'm sure too, the guy with the diabetes and the black toes that are falling off, and he says, I'm good, I'm going to put a little Neosporin on that. We'll be all right. We're going to be okay. So the more irrational the basis for denial and the more serious the medical issue at play, the more that's what this definition is aiming for. And I think it's from a political Sacramento angle. There's people on the street, they're wallowing in, filth and open wounds, etc. We can't live with this anymore. I get it. I agree. We can't live with this anymore. But if the solution is take them all to Char Mesa Vista, well, that's not gonna solve the whole problem either. So the more serious the medical issue, the more the decision to not address it seems to be rooted in mental health or substance use or both. That's what this is getting at. And it creates an interesting dynamic because, again, civil rights guy, sorry or not sorry, but if I have the right to say no to medical treatment, which I still do, you can now bring me in and detain me because I'm gravely disabled. I can say, no, thanks, I don't want that treatment. But in theory, we're now stuck because until I agree to do what you want me to do, I guess I remain gravely disabled. So is that now going to be something where you all, whether you want to or not, can sort of compel that treatment? That because you're still gravely disabled until you agree. And let's add another problematic layer. If you're detained and taken to a freestanding psychiatric hospital that doesn't have medical capability to address these things, well, what is that going to look like? You took me in because I wasn't availing myself of medical care. You took me to a place that can't even provide it. So that's something that we're going to have to work out what that means as well. Yeah, that's right. I see what Marina put. Yeah, they sell the right to refuse, but you can say, Mike, you can refuse all day long, but until you agree, you got to stay here. Now, that's not a win for you either because you got to move people along. You can't just keep somebody and wait them out. So we're just exploring sort of the parameters of what this might look like. This is not designed to have all the answers. It's just designed to help everyone think about what the implementation is going to look like. All right, next slide, please.
I see Lauren's hand up.
Yep, please.
Hey, can you guys hear me okay?
Yep.
Oh, hey, sorry if this is a silly question, but does the expansion of this definition, particularly here, the personal safety and necessary medical care, have any relationship to any considerations for things like reseeing an individual or conservatorship applications? In other words, are these, for this? Okay, yeah, you first.
Absolutely. In fact, let's go to the next slide because it's a perfect segue. So nicely done. I think what did we agree to? $10 for that perfect transition. So this was designed at the Sacramento level to make it easier to put people on conservatorship. That was their goal. That was their plan. But to your point, this definition runs throughout all of these holds on the screen. The 5150, the grave disability expansion applies to that. If someone's having one of these hearings in the non-LPS facility, those of you that have had to do one of these hearings in your non-LPS emergency room, it applies to that definition of grave disability. You put them on a 14-day, you put them on a 30-day, a second 30-day, or conservatorship, that definition applies to all of those. And then all of those same individuals could be REISed. And those of you that are not familiar with REIS is a hearing, sometimes called capacity hearing, based on a case called REIS versus St. Mary's, that basically says if the patient is refusing psychiatric antipsychotic medication and you all feel like that's due to a lack of capacity, you can request this capacity hearing, and then that would be determined at that hearing whether the person lacks capacity. And if you, the hospital, are you win that hearing, we don't like to use win or lose, but if you are successful in that hearing, then you can medicate that individual over their objection for the remainder of that hold. If they go to the next hold, you may have to get another REIS. But yeah, this would expand, in theory, the number of people that would be REISed, the number of people placed on conservatorship. It could apply to all, well, it will, the definition will apply to everything you see on the screen, and how that looks in a capacity perspective or number of people placed on conservatorship. The biggest pushback when we talked about this on the forefront was, where's everybody going to go? Because conservatorship, there's no places. Well, Prop 1 is going to build some places, right? We don't know how long that's going to take. We don't know what kind of places. We don't know where. We don't know who all is going to have access to those, how many beds in each county or each hospital is going to have access to. But this is designed to put people on conservatorship and put them over there. That's not the way that Sacramento would describe it, but that's the way I'm describing it. Okay, next.
Yes, Roseanne.
Oh, or questions? Yeah, please.
Hi, Mike. It's Roseanne.
Hey, Roseanne. How you doing?
I'm good. How are you?
Good.
Thanks for doing this. It was a really good review of LPS law. So here's my concern. We have PERT, and my understanding is none of the PERT clinicians are nurses. So what training are we going to provide for PERT related to the medical portion of this expanded definition? Because what looks really, really bad to them, they get to this ED and it's not going to be really, really bad to us. So it's going to be a lot of unnecessary trips for them. And I know it's probably not fair to expect them to really be able to, decide, is this a really serious medical condition? So what's your thoughts about giving them a little bit extra training?
You're exactly right. And it actually goes deeper than that. We've been having a lot of conversations. In fact, I just presented, some of you may have seen me a couple of days ago, I presented at the Scripps Sharp ED Collaborative. And a lot of EMS questions came up about, once you call EMS and an ambulance into the picture, in some cases, they see a medical situation, they're going to send that person to get medically cleared, even if it seems to be lower level. And here's the real rub on that one. We're now going to expand grave disability to use 5150 to take someone hopefully to the right place, which would be a LPS facility or a behavioral health unit bed. But we're going to add in this medical criteria that in some cases, when fire, when ambulance, when EMT, when everybody shows up, EMS, are going to then take that patient, and because of that very same medical reason used to place them on the 5150, is going to divert and send them to some other place that is maybe not an LPS facility. And then that non-LPS facility, who's presumably expected to treat the medical issue, is going to say, don't bring them here. They're on a 5150. We don't treat 5150. So we're going to see possibly some real sort of ping pong back and forth. I mean, there's some very real things that can go wrong and or be more resource intensive and actually against the will of what this law was about. Because if you put me on a hold because I'm not availing myself of medical care to send me to Sharp Mesa Vista, and then EMS sends me over to Scripps Encinitas, well, then we got a problem. And so that's something to keep in mind as well. And I think in answer to your question, I think that if you look at these definitions, the necessary medical care, the severe substance use, those are things that I think we should feel only really comfortable with, those things being assessed by clinical professionals trained to do so. I think we should not, I think it's dangerous to ask or even try to get law enforcement to be making those nuanced assessments. And if we add in PERT, and PERT's fantastic, but you're right, PERT's law enforcement with a social worker for the most part, they're not going to be trained in those nuances as well. I think we're going to have to assume that the initial 5150 done in the field by law enforcement is going to be what it's always been, which is a best guess as to what appears to be going on, while they bring that individual to you all, the professionals, to sort it out. And where that becomes a problem is exactly what you just described, where they see something that seems very dramatic to them. And when you get it, you say, I'm not seeing this at all. So there's going to be a lot of assessing and then maybe cutting individuals loose, which is tough because that's a churn and that's a lot of resource intensive stuff as well. But I wouldn't want us or anyone to be necessarily providing intensive clinical training to PERT clinicians. I think we need to stay in those broad descriptors, and that's what we're working on right now with law enforcement and others. Is what kind of observable behaviors when we're implementing this at the meetings with law enforcement, they will say we ran these scenarios. Dr. Krelstein, Dr. Esposito ran these vignettes. Person's dealing with a blood pressure of this and a blood sugar level of this, and the cops were like, "We don't understand any of that stuff." Like I see a guy who's bleeding out. I see a guy with a gaping wound or laying in the street with his head cracked open. Like that is, I get that, but I'm not going to understand all that other stuff. So I think we just need to be realistic in what people are going to be able to determine. And unfortunately, I think that's going to mean people coming to you. You're right. Training MCRT. We're doing trainings for PERT, MCRT. We're doing all those trainings, but expecting all those individuals to come out trained professionals like you all are in your various disciplines is not realistic. And I also think potentially dangerous if they start acting in that capacity. Okay. Good to see you, Roseanne, always. All right. Weapons, you want to talk about these? Meryl, I mentioned it earlier, but.
Yes, I do want to add just a quick comment just for a little bit of reassurance, as much reassurance as we can give. We recently were vendors at the Southern California Emergency Care Conference, and we were able to make direct connections with EMS, so the LIFT program, Falc, CARE, Premier, San Diego Ambulance. So they're looking at the training materials that we already have, and they're kind of taking the time to deduce what they need to know, what we can answer, and what's within the scope of their practice. So that will be addressed to the best of our and their ability. So moving on to weapons prohibitions, I'll try to keep this one as simple as possible. It can be helpful to read off the screen just because, so individuals detained pursuant to 5150 in an LPS designated facility under this new definition of grave disability will be placed on a state Department of Justice prohibition for 5 years from the date of the 14-day hold, but can be challenged in court. And on the other side of the coin, people detained pursuant to 5150, also at an LPS designated facility, placed on a 14-day pursuant to the new definition of grave disability. The different component is if they are not successful in their automatic due process hearing, they'll be placed on a federal DOJ weapons prohibition for the remainder of their lifetime. I don't know if Mike, you want to elaborate on
No, I mean, we got a whole training on that, and it's pretty interesting, but it's more than we can do here today. So if anybody wants the training on all the nuances of the weapons prohibitions, we'll do that training as well for anybody that wants it. I want to acknowledge Sergio's comment in the chat. Yeah, this is the age-old question of how do we take people off a hold, and is there a mechanism to do that? If someone is fully placed on an LPS 72-hour hold, meaning they were brought in pursuant to 5150, got assessed, then got admitted, keyword in the law is admitted, presumably to a BHU, then they're on a 72-hour hold, and there's very clear guidelines on who can DC that hold. But all those people stuck in the middle that never made it to the place they were trying to get, there is no guidance as to how you can DC that detention or how to do it. California Hospitalization, and I worked with them on this a few years ago, and some others tried to get a bill passed called AB 1300 that would answer a lot of these questions. It didn't pass. NAMI had concerns, and NAMI was able to block it, and I get it. But really, it's left to individual risk counsel and providers to decide how comfortable they are stopping detaining someone. For me, logically, if law enforcement that's not clinically trained brings someone to you all, and you clinically feel like, no, this is not happening, you should be able to override and supersede whatever the law enforcement individual thought. That makes no sense that you should be trapped by what someone in the field in a non-clinical capacity said should be detained. And there's language that says if a person can be released safely without being detained and given resources, then that should happen. So I think it makes sense for each hospital risk counsel to say, what does it mean to us that we feel like documentation-wise, we document that, yes, this person was brought in on 5150, but we don't see it. Either we never saw it, or we can get why maybe it was happening in the beginning, but we don't see it anymore. We're going to let this person go. The law definitely allows for that. It just doesn't say how to do it. If you want to talk more about that, we can talk about that as well. And then Kevin's comment, I think you're exactly right. This is going to be really tough. Somebody has an overdose, or there's a propensity for a future overdose. At what point do you say, I feel comfortable letting this person go? And if you have a duty to detain this person. We have not seen yet anything that requires, that mandates that you must detain someone pursuant to 5150 if anyone, or excuse me, a definition of grave disability, danger to self or others, if someone might arguably think you should have. Although if there were a lawsuit, and as far as we know, there's fairly few of these, but that doesn't mean you don't have to worry about it. If someone accuses you that you should have done that to prevent the bad outcome, you're exactly right. This is a slippery slope. You all are being expected to predict future behavior, which we all know even the best clinicians are not able to accurately predict future behavior, even based on current dangerous behavior. It's nearly impossible to predict. So you're going to have to decide what that looks like. And we're going to have to decide as a community of someone who has severe substance use and could overdose in the future. When do we feel comfortable letting them go? These are open questions. Really good question. And anyone that wants us to do any trainings, please reach out to anybody at Sharp. Everybody knows how to get a hold of us, and we'll put our information in the chat too. We'll do trainings on anything, anywhere, all the time. All right,
We'll
couple
take
more
you up
slides.
on that.
Okay, good. We're running out of time, and I want to make sure, and I'm hoping we can go a few minutes over into what was going to be the discussion time anyway. We just got a few more slides, if that's okay.
Absolutely. Sergey, I just wanted to check, do you have an additional question? Or Dr. Phillips, I saw your hand up.
Great name, Dr. Phillips.
No additional questions. Thank you. Mike answered that greatly. Thank you.
I can wait for the discussion also. I advocate, I spoke to clinicians. I went up to Sacramento for an Cal ASAP meeting, and I spoke to clinicians from UCSF, and they are an LPS. The clinicians, the ER physicians, have the ability to remove holds.
Was there more? You cut off. I couldn't tell if that was the end of the sentence. Did we lose you? I'm going to assume that maybe that was the end of the sentence. That I think is tracking what I said, which is in each county, there's sort of a determination made in some cases from one hospital or system to the next of what they feel comfortable about discharging someone. I would argue someone's brought in by law enforcement. They are not clinicians. You all are trained professionals. If you believe that you are not seeing that, what they saw, or that you're not seeing it anymore, I believe from a civil rights perspective, you have a duty to stop detaining that person pursuant to 5150. And for me, it would just be about documenting very clearly in the record why you don't see those behaviors or symptoms existing anymore, or existing to the point where they would cause danger. You're not seeing mental health at that high level of acuity. You're not seeing severe substance use at that high level of acuity. And you're not seeing the elements: food, clothing, shelter, physical safety, danger to self, danger to others, medically necessary care. If you're not seeing that anymore, our system's already jammed up with too many people trying to get to the right place. To then force those in some counties like LA, I don't know if it still happens, but those individuals, even if all the clinicians are looking at that patient in the ED saying, and they're not a non-LPS facility, this person doesn't need to be here. Some of those policies are that you must still wait for a bed to open, send them to a behavioral health unit, and have that person stop the detention, which I get it from a risk perspective, but that is a really bad systems way to handle things, and it's really bad for the civil rights as well. So these are conversations that have already been around for years. They're going to all come up again in a new way with SB 43. All right, a couple more slides, and then we can keep discussing. This is key. Well, it's all key, I guess, but designated facility. LPS talks about how you put people on a hold and where you can take them. And you're probably already thinking, well, severe substance use, where is that place? Well, not only where is that place, but the current definition of designated facility does not even allow any of these people placed on the current or new definition of grave disability to go anywhere other than the same old places, meaning a general acute hospital, psychiatric, freestanding, emergency department, or crisis stabilization unit. So unless this definition changes, you couldn't take somebody to any other place even if you wanted to. And most of these places, if not all of them, are not designed or really good at treating severe substance use. So there is a bill right now in place called SB 1238. The goal, and it'll likely pass, but the goal of that is to broaden the definition of who can be designated, what kinds of facilities. And I don't like that one because for a minute it included like skilled nursing facilities, which in my opinion, nobody on a 5150 should be taken to a skilled nursing facility. But it adds in other types of facilities like social rehabilitation centers that could presumably include our crisis houses, which I think that doesn't really make sense either. Long-term care places like mental health rehabilitation centers like Alpine, Crestwood. That doesn't really make sense either. There are people on conservatorships in those facilities, but to take someone on a 5150 there, also the only mention of severe substance use is it does acknowledge that you could take someone to a designated facility, which in the future, under this new definition of designated facilities, would include ASAM level 3.7 and 4.0 facilities for severe substance use. That sounds great on paper, but though, to my knowledge, those places do not exist. They don't even exist. So by creating a pathway on paper to have that be a designated facility, but to not yet have that facility to exist, never mind the reimbursement that would need to be in place to provide for reimbursement for those treatments, that's going to be a lot of work that still needs to be built. And I recently was in a debate with somebody about this. This is Mike, well, there's no problem. We're going to increase who can be LPS designated. And I said, nobody wants to be LPS designated. People are trying to get out of being LPS designated. Our whole Palomar system just got out of the business. Tri-City a few years before that, they're getting back in a little bit, but to create more people who can become LPS designated, in my opinion, is not wise if those are not the proper facilities, and those facilities are not going to want to be LPS designated anyway. So the only value I see in that is it creating a pathway to the eventual 3.7 and 4.0 substance use facilities. But until those exist and are built and have reimbursement models around them, we still got a lot of work to do. All right, next slide.
Okay, we'll keep this one simple so we can keep moving and then take other questions. So who can initiate 5150s under the LPS statute? Sworn peace officers, so law enforcement, attending staff at RLPS designated facilities, members of a mobile crisis team such as MCRT, and other professional persons designated by the county. Next slide, please.
And then locally, the Board of Supervisors, under the LPS Act, the counties can identify and empower additional individuals to initiate 5150s. And this is the slide that indicates who the County of San Diego has additionally said can initiate 5150s. This will likely all be up for review and change as we go into SB 43. I imagine they're going to want to add substance use clinicians. Also, if anyone wants a copy of the board letter that lays all this out and has the exact language, we're happy to share that with you all as well. Let's go to the next slide.
Okay.
Kind of already talked about this one, but go for it, Miriam. Everybody needs training.
This is exactly, and this is our big list of ideal audiences that we are reaching and in the process of reaching. So law enforcement, we're reaching them and trying to get them up to speed by January 1st. We're working with PERT, MCRT. We're attempting to get super connected to the mental health court judges since, you know, they make those decisions in our hearings. Office of the Public Conservator. We're also attempting to reach, you know, family members, people with lived experience as well. We've been able to connect with a lot of consumer groups, and that's been really impactful how we've been able to provide the education. But as a whole, we are looking to reach anybody and everybody. You can go to the next one.
Other now less sexy changes to the law under SB 43, and we'll go through these pretty quickly, but I don't want to miss them. 1799.111, the terribly named code section of health and safety that many of you are familiar with. This allows non-LPS designated facilities to initiate what used to be an 8-hour detention. Now it can be a 24-hour detention. It's not a new hold. It's an immunity for people detaining people in non-LPS settings while trying to get them to an LPS setting. Basically, SB 43 says that anyone using that tool, the new definition of grave disability will apply to that as well. For SHARP and for Scripps and for other systems that have a big network, most of you already have liaisons and things that you don't really use this 1799.111. But I just wanted to call out that it is part of it, part of the new law. And then lastly, I referenced this before, not lastly, but very close to lastly, but I referenced this before. There will be changes. There's a new hearsay exception being created. Some physicians will not have to go downtown for it's specific to conservatorship appointment and reappointment. This doesn't speak to the writ hearings, which I know for some of you, that's a real burden to have to go downtown for these writ hearings. But for conservatorship appointment and reappointment, under these very specific conditions, may be able to not have to go downtown and testify, and some other clinician could testify in your place and read from the record. As a lawyer, I read this, and these are a lot of hoops that need to be jumped through that at the end of the day, you may say, you know what, it's not worth it. because somebody's got to go downtown to ask for permission for me not to have to go downtown, then what is the point? So stay tuned on this one. We'll see how this gets implemented.
Okay. So another change required by SD 43, and I'll try to keep this one short and simple. Before placing an individual on LPS conservatorship, of course, we want to explore all options that they can receive the care that they need, including on a voluntary status. And that includes assisted outpatient and the CARE Act. So as many of us may know, the CARE Act was enacted hopefully to support people in receiving voluntary treatment, and it only applies to individuals with schizophrenia or other psychotic disorders. So we're seeing a lot of that with struggle with medication compliance, struggling with housing. Several different kinds of individuals can petition for this.
And this is really just kind of cleanup language. It already said in conservatorship that all other lesser restrictive measures must be considered before placing someone on conservatorship. This is just adding in some of the new things, saying don't forget to consider these directly. And for you all, that can be a problem if you're saying we want this person to be considered for conservatorship, and then the conservator's office is saying, well, wait a second, we should consider them for care court first, and then the timelines get wonky and who's waiting for who and under what legal authority am I holding someone while I'm waiting for this other party to act. So this all sounds good on paper, but like everything else, it can really get jammed up in practice. Next slide, please. These last two are about data collection. They want data to be collected on who's being placed on danger to self, danger to others, and then teasing out on their grave disability, who's being placed on 5150 for mental health disorder, severe substance use, or both. I don't like this at all because I know law enforcement is just going to put both, because why wouldn't you? You just put both, so you're not going to get good data. And I assumed on the new 5150 form that's going to be used for this that it would have little boxes so you could check one of those, because otherwise, how else are we going to collect that data? Well, the new form's already out, and please don't use that one yet until January 1st. The current forms are all on our website, so just go to our website and you'll always have the most current form. But if those boxes are not out there on the form to tease out that data, how are we going to tease out that data? I don't understand. Anyway, next slide. There's additional financial penalties to, it was going to be to the hospitals, but now it's to the behavioral health director if the data is not collected timely and appropriately. So with that, and thanks for letting us go a little bit over, but we also were including discussion along the way. We are now at the end, but we now defer to all of you. How can we be helpful? Some discussion, follow up. What do you want to do? We'll do whatever you want.
Well, first of all, thank you very much. That was a great overview. And Mike, you said we didn't have even an hour of content. I think we could talk about this for multiple hours. But yes, we will open it up for questions and answers. As a reminder, we also do have Dr. Nicholas and many other clinicians throughout the system. So this is really meant to be a space for us to have shared discussion and talk a little bit more about the content that we just saw. Let's go ahead, and I see Denise's hand up first.
Hi there. Thank you. I just wanted to throw it out there, Mr. Mike Phillips, about a special population that we have that sometimes goes without getting their needs met. It's the older adults who wants to have ambulation issues, walkers, PT needs, dialysis. There's a difficulty finding facilities even when they're voluntary. So I was hoping that you could just like a reminder that these folks exist and need care.
Yeah, I mean, I was presenting at a conference for California Hospital Association where Eggman Talamantes, who wrote this bill and passed it, was presenting, and she said, we know there's no new money and we know there's no new resources, but we want to point the compass to the North Star. So, I mean, that's all sounds fine and good, but until there's money and resources and facilities, exactly what you just said, we still have all the same old problems as we had before. So some might argue that we're putting the cart way before the horse on this one, but you're right. All the same people that have all the same needs we still have that problem. And now we're going to, in theory, bring a whole bunch of new people, whether it's in volume or complexity of whatever clinical pattern you're dealing with, that we're just going to have to figure out what to do while we wait for resources and things to come and backfill that.
Yes, Lauren.
Yeah, silly question. I know you commented on this earlier, but how does the grave disability definition for minors relate to this updated guideline? Or does that still supersede these guidelines, and that we couldn't hold a minor for, say, alcohol use that would otherwise be impairing under this new definition?
Yeah. So, and part of this is a legal technicality in the way the case law has landed. So I won't bore you with that unless somebody wants to be bored, and then just call me. But the old definition of grave disability remains for minors, but only for the first 72 hours. So you're right. You couldn't bring in or detain a minor with severe substance use. But if somehow they were detained under mental health for 72 hours, then you could start detaining them under that new definition with the 14 days and beyond. Now, in reality and in practice, all these definitions are going to get blurred and unintentionally blurred, intentionally blurred. But technically, you're exactly right. Mental health only for detaining a minor for the first 72 hours. After that, full-blown grave disability definition that's going to change on the first. Very, very confusing. Not easy to apply. Dr. Nicholas.
Thank you, guys. That was great. And it's a very complex issue, and I'm sure we will need more guidance from you down the road. A quick question. I have two questions. The first one is, what has been the experience of other counties that already started? Was there a wave of influx of patients to the emergency room, or are we just worried too much?
Yeah, as I said earlier, the data from those counties has not been super helpful. I mean, San Francisco, as I'm told, only has like the one hospital. I don't know if that's true, but I'm told they have one hospital. That's right, but maybe one LPS facility. I'm not sure. But and then San Luis Obispo, they've got some numbers, but the numbers are, there's not a lot to be gleaned from the numbers. Their numbers show that of the people detained pursuant to the new definition of grave disability, about 12% of those were for the severe substance use piece. But that doesn't tell us if that's an additional 12% that would not have already been detained, or if that's the same old Bob that in the past got detained under the old definition, but he also has severe substance use, and now we're calling that out in the new data collection. So the data, I would say there's not enough to glean from it to get a sense of what we're going to be dealing with. And, you know, your San Diego's, your Orange Counties, and your LAs are going to be the ones that are really telling because of the size and the number of facilities and the size of the population.
Thank you. And the second question is, can you clarify a little bit? We heard earlier in the year that physician assistants or nurse practitioners can testify on behalf of the physician in court. Is that something we're seeing now?
So the definite there. So I'm imagining that we're going to see, especially with the likely change in the Board of Supervisors' authority of who can initiate 5150s. The whole concept of nurse practitioners has come quite a long way in the last few years, and I would imagine that you're going to see more acknowledgement of that. But the hearsay exception, I'm trying to remember who it says can go downtown. Let's see. I'll have to look at it. I think it just says basically that someone doesn't have to have been the one who originally witnessed the behaviors, which is what hearsay is all about. You're not supposed to testify to things you didn't actually see. I don't think it defines who it is that can testify in the physician's place, and it may be even more broadly than a nurse practitioner. It may be social worker, maybe nurse. I'm not sure. I'll take a look at that.
Thank you. Thanks
Yes,
again.
Steve.
Steve.
Hi. Yeah, I work at Mesa Vista, one of the nurses. So we've had over time an increase in patients who are waiting for conservatorship and that whole process, and then after they get conservatorship, assuming they do, then it's a long wait for placement. This looks like there's going to be more patients in that boat. Is there any kind of thought on where they're going to go? I mean, are all the acute beds going to be filled with patients waiting for a facility that doesn't exist? Or?
Yeah. So the short answer is probably. I think a lot of this is going to come down to how you all adjust or do not adjust who you are deciding to petition for conservatorship. And I'm imagining that logjam is unintentionally or unfortunately going to affect who you are requesting to be placed on conservatorship. We're going to have to see how the conservator's office responds, because the conservator's office is sort of a gateway to this process. but they don't have a magic pot of money and they don't have a bunch of extra beds and facilities. So without a place for people to go, and that really is what Proposition 1 is supposed to be about, among other things, is here's almost $5 billion to go build a bunch of facilities or rehab facilities or whatever. About half of that's going to go to new treatment facilities. About half of that's going to go to permanent supportive housing or facilities like that may or may not have facility treatment connected to them. Also, Prop 1 is going to carve up what used to be the money coming from the Mental Health Services Act, which was about $3.3 billion out of the $12 billion statewide behavioral health budget. And it's going to carve out a billion of that across that pot of 3.3 billion to go towards housing. And then some unknown mix between what remains will go to either mental health or substance use services. So housing and substance use, great, but that's a reminder that's going to come out of the existing old pot of mental health dollars, which for the most part are already committed to existing resources. So somebody's going to have to build some stuff, and they're going to have to build it fast. And that's going to be that's the next thing to keep our eye on is Proposition 1 and the implementation. Who's building what and where? Who's got access to it? How many beds are you all going to have access to? What's that impact going to look like? Because I do think this is kind of like a lot of the ways that humans solve problems. We don't like seeing this thing. Let's put this thing over here, over there, where we don't have to see it anymore. And it's not that simple. And that's not a humane and dignified response, in my opinion, to the unhoused population. But until we've got places for people to go, yeah, what happens when all your beds get even more jammed up with people awaiting determination for conservatorship and pending placement? Something else to consider.
Yeah, and I think it's also a great reminder that, conservatorship does not guarantee placement. The conservator's office cannot mandate that someone is placed in a locked facility. Those facilities have their own review process and determination if they meet the criteria for that individual facility. So we really have to think about, the goodness of fit and how this policy, impacts practice. And just because we can doesn't mean we maybe should. Yes, Victoria.
And is Alpine and the Crestwoods, are they ready to start doing full-scale severe substance use treatment? I don't know. I would imagine probably not. So even if they're willing and able, if they're willing, are they able to provide that care?
Victoria, I see your hand up.
I've seen people on lists for IMDs for years just waiting for a bed.
Yeah, I'm sure you guys have multiple people you already know of that you've been waiting for a year, 2 years.
I just wanted to, there's a question in the chat. So what legal authority do we have if the patient wants to leave at the non-LOS facility, just like the AB 2275 call the SPD non-LPS?
Yeah, so there's really, as I mentioned before, and it applies to both LPS and non-LPS, there's really no clarity around what it looks like to stop detaining someone pursuant to a 5150. Although I can't imagine that for fear of that, we just keep detaining everybody indefinitely, because that if you're in a non-LPS facility, that 5150 is going to run out, and then you don't have anything beyond that. Even the new 2275 hearings or 5256B hearings, whatever confusing name we want to call it, even that is just a due process hearing for the patient and does not create any new ability for you to detain anyone after the 5150 in a non-LPS setting. So I would say that one could argue you have a mandate to let them go after the 5150 expires. We all know why there's many reasons why you wouldn't want to do that. You've got a really messy clinical picture, a bad outcome that you're afraid of. So after the 5150 expires, or even before, it really comes down, I think, until we get clarity from the law, to a risk and clinical team and maybe counsel decision as to what we're going to do with this patient. You may just decide to keep someone without any legal authority to do so, and you may just decide you have to do that, and you'll take the challenge if there ever is one. But there isn't really any guidance or protection in the LPS or non-LPS world of stopping detaining someone pursuant to 5150. But I think framing it as this is a civil rights detention, the clinicians are not seeing the threshold being met and the criteria being met, we cannot in good conscience detain this person. We got to let them go. It's messier, I think, when you decide that you're going to keep detaining that person without legal authority. And both of those are really uncomfortable places to be in. And none of this new legislation brings any new resources to bear, at least not yet, to answer those questions or take any pressure off of that dynamic.
I do want to put a quick just practice plug in here for all of our providers at non-LPS facilities at any of our hospitals or emergency departments is just the importance of entering into Epic, the hold. So if that 5150 is established in the community, ensuring that that order gets into Epic, so that way there is transparency and we can make sure that we are getting those patients their due process hearing, the 2275 hearing, if that 5150 that is going to continue on past the expiration while we're waiting for a bed at an LPS facility. So if you have any questions about how to enter that order in, please reach out to your hospital's nursing educator to get support with that. But that is a function that is in the system. We've been validating it. It's available, and that does help all of our hospitals then be able to track who is on a hold. Yes, Dr. Nicholas.
I was just going to also remind people that people who do not have psychiatric or substance abuse problems in a non-LPS facility, we have other options that we created by sharp policy, the medical incapacity hold. So I know it's a complex picture. Hopefully, we'll be able to create some sort of a diagram to help you understand who goes under what bucket and kind of the process depending on where you're at in the system. It's complex, but this presentation helps us at least get a general idea. I know it's overwhelming, but we'll get through this together.
Yeah, and I just put in the chat. Oh, sorry. I just put in the chat about what Josh was saying about the 2275 hearings. I put a one-sheeter that we created in the chat. So if anybody has questions, that kind of breaks it down. And if anybody wants trainings or guidance or assistance on that, we can help with that as well.
I wanted to, Mike earlier mentioned ASAM and the different criteria. And this is not LPS, but I do want to point out for Sharp HealthCare that we are one of the only, I think, if not the only organization in San Diego County that does have all these different levels of care, ASAM levels of care. So this doesn't solve the part about involuntary treatment and all of that. But as far as treating substance use disorders, we have a very dynamic addiction service line. Dr. Nicholas leads that. If you ever get a chance to attend, I encourage you to do so. There are patients who get brought into here. There's an intervention from residential, outpatient, inpatient. So it's really a powerful intervention, and something that's very unique to Sharp HealthCare that we can treat at all of these different levels, not necessarily on an involuntary status, but through voluntary means. What we do need to advocate for is what Kirsten had mentioned. We got to make access to this and the payer side accountable for really supporting folks who want treatment. But I did want to point out that because that is a unique kind of feature of Sharp HealthCare and something that we should be proud of, that we do have that continuum of care.
There's another question in the chat from Sergio. So at the county level, is there a plan to add clinicians trained in mental health issues to PERT or similar field response teams, or are they already part of those teams so that unnecessary 5150 hold are not placed in the field by law enforcement?
Yeah, just a reminder for those who maybe don't know, PERT was a response back 26 years ago now to some bad outcomes when law enforcement showed up. People's homes, people died. And so the idea was to have law enforcement in the driver's seat to provide safety, and then a clinician to really get that nuanced assessment and also de-escalate the situation as much as possible. I believe PERT only hires licensed social work clinicians. So to whether they're going to hire more, PERT has been expanding and expanding and expanding. Still not enough, but we have a wealth of clinicians compared to other counties. I would imagine that there's probably a plan to expand more, but I don't know if there's going to be specific additional training than what's in place. But PERT's super transparent about that stuff, so either you all can ask them or we can ask them. They'll tell you.
Yes, Dr. Cazares.
Hi. Hey, Mike. It's Paulette Cazares. You may remember me when I was in uniform at Balboa.
Yeah.
Hi. So may have missed it, but neurocognitive disorders, is that captured under mental health disorders now or still separate?
The definition of mental disorder has not even under the law, but under some attorney general position that was so old, it was like 20 something years ago. It basically sort of loosely punted to the DSM at the time. And so anything that's sort of traumatic brain injury, even stuff like, Alzheimer's, any sort of things that are not sort of, I think the concept behind that was, from a logical perspective, is you're taking someone who's dealing with a crisis to a place that can alleviate and mitigate that. If you have something that maybe is beyond our current ability to mitigate in a short-term hospitalization, then maybe those individuals should go to some other place. We all know that those individuals get caught up in the existing net of 5150 and likely will continue to, because those behaviors present in ways that we wouldn't expect law enforcement or first responders to maybe suss out. But at a hearing, at a due process hearing, they really should not be allowing those holds to be applied. But we do thousands of those hearings, and we see hearing officers who are human who will basically be like, I'm just going to let you do it because this is a really bad situation and we're not going to send this person back to the street. But technically, no, it should not apply.
Okay, thanks.
Yep, but it will in practice.
Right.
Sometimes the conservator's office, who has to deal with all these requests and doesn't have enough resources and beds, will get into those kind of weeds. And at the conservatorship level, will push away from those diagnoses because it's a way to sort of focus their limited resources on exactly what the law is supposed to be about. But I would imagine until you get to that conservatorship phase, probably it'll all get blurred together.
Okay, cool, thanks.
Yes, Dr. Phillips.
Do not know exactly what happened earlier to my audio, so I have no idea what was said. But nonetheless, I advocate, of course, that ER physicians at an LPS facility who have been approved by the county to place and release 5150s remain that way.
Yeah, that'll stay. That'll stay.
Okay,
Not,
and then
I don't have the, I'm not the decider on that, but I can't imagine that's going to change.
and there is nothing that would advocate for a non-LPS emergency department to also be able to lift holds placed by sheriff and PD. Is that
Yeah,
correct?
we talked about that a little earlier, but I think my take on it is, all due respect to law enforcement, they are not trained clinicians. So if they bring someone in saying, I don't know what this is, you guys are the professionals, that it would make no sense for the professionals to not be able to say, well, we disagree, cops, and we're going to let this person go. It would almost be like, to make it extreme, if the cops dropped them off and say, hey, and I'd like you to get them started on this medication and keep them for this many days. I mean, obviously that doesn't make any sense. So I think the net is broad. Law enforcement, first responders are broadly going to bring people to you all, and you can and you should and you must whittle that number down to people that you believe need to be there. And you must be able to release people before that. It's just that the law is silent prior to someone ending up admitted to an LPS facility, which we all know a lot of these people are stuck in this purgatory. The law is silent on how to do it, but it doesn't say you can't do it. So I would just direct you all back to your risk, your clinical team, your counsel, and say, how are you all comfortable doing this amongst yourselves?
And does that apply for a 5150 placed by PERT? Or
yeah, there's no PERT's wonderful, but there's nothing more super powered to a PERT placement of a 5150 than law enforcement doing it. There's nothing, there's no extra magic around it. But I would imagine that if I were you and I were a clinician, I would say, since a clinician has weighed in, I want to pay particular attention to what that clinician's analysis and observations were. But you should not feel pressured to maintain a hold that you don't believe in just because it came from PERT or MCRT or law enforcement. If you're not seeing it, you're not seeing it.
So that would apply to, of course, Grossmont, that's an LPS. The ER physicians can, in fact, remove a 50-50 placed by PERT. And would you advocate the law allows a non-LPS ER physician to also do that?
Not well. So the law allows the individual counties to empower who can initiate 5150s at a non-LPS facility. And currently, under current board authority, that is emergency room physicians at non-LPS. So if they can initiate it, it'd be very strange to say they can initiate it, but they can't turn it off. I mean, that just doesn't make sense. It doesn't say that they can, but it doesn't say that they can't either. So I think that basically feeling like all your beds are going to be tied up with people that you don't believe are meeting criteria, that does not make sense. The net is broad on the front end to get people to your professional analysis and assessment. Once you've done that, it doesn't make sense for you to be beholden to that really broad net dictated by non-clinicians. And I know PERT's got clinicians, but they're still just initiating 5150. They're not going to dictate treatment. They're not going to dictate what treatment is being provided and for how long. So you're not beholden to that. I would consider it, because of the clinical flavor added to that assessment. I consider it more closely, but you don't have to uphold it.
Lastly, I have to fill out some sort of test or form every 2 to 4 years to
Yeah.
remain, quote, certified by the
Yeah.
county to place and remove 5150s. Does it behoove other physicians then at other non-LPS facilities to apply for this? Because
and they are.
I'm not sure we do at Sharp.
Yeah, I don't. We Dr. Nicholas and I talked about this a little while back, and I think we came to that same point where I'm not sure to what extent you all are doing this, but other providers are doing this. So we're in the transition phase right now. We are, at the county's request, we are about to take over that whole process, the training, the certifying, maintaining of the process, the test and all that good stuff. So we'll be doing that soon. But any ED providers out there in the non-LPS world, and it's emergency room physicians is what it says, they can, and I would say should, reach out and get that authority, because that was the idea, is that not everybody is going to show up at the right place or be brought to the right place. And
all right. So perhaps for Joshua or anybody on Sharp, we need to work on this.
Yeah, that would be a determination for Sharp as to who's doing it. But under the Board of Supervisors authority, that power exists. All you got to do is reach out, get the training, and training's not hard. So it's available if you want it.
Wonderful discussion, and we are a little 5 minutes past time, so thank you everyone for hanging in there. Just a quick reminder, if you have not done so, please text your attendance so that way you can receive credit for this session. Thank you again, Mike and Marielle, for the wonderful presentation. Again, it is a lot. That's a lot of information in there. This will be recorded, so if you want the pleasure of watching this again, you will have access to that. But we really appreciate you partnering with us and providing this education. It's very meaningful to us as we continue to work to meet the needs of our communities and providing great care. I hope you all have a great day. Take care, everyone.
Thanks for having
Thanks, everybody.
us.
Thank you.
Bye.